Good afternoon, and thank you so much, everyone, for joining us today for the latest webinar from the American Bar Association Civil Rights and Social Justice section, brought to you by our Education Committee. I bring greetings from our section chair, Wendy Mariner, and the Education Committee co-chairs, Christy Susie and Cynthia Swan, and Special Advisor Beth Wittenberry. Thanks also to Jerry Gardner, our section director. I'm Janelle George, a co-chair of the Civil Rights and Social Justice Education Committee as well. But today I'm speaking in my personal capacity. I would also like to thank and acknowledge the sponsoring American Bar Association entities, the Division for Public Education, the Standing Committee on Election Law, the Center for Public Interest Law, the Center on Children in the Law, the African American Affairs Committee, and the Section of State and Local Government Law. Please note, the views expressed herein have not been approved by the House of Delegates or the Board of Governors of the American Bar Association, and accordingly should not be construed as representing the policy of the American Bar Association. They are the views of the individuals themselves in their personal capacity. Today's webinar features legal experts and advocates, and again, what is the second of a total of 4 webinars of our webinar series, Education and Democracy. In today's webinar, speakers will explore the disparate impact legal theory and its significance for protecting civil rights in education and addressing discrimination in a variety of areas, including school discipline disparities. Speakers will explore how the history and significance of disparate impact as a leading legal theory, and they'll also discuss recent attempts to erode it and how those attempts can impact students' civil rights and access to equal educational opportunity. So we'll begin with an introduction of our speakers today. At the end, you will have the option to ask questions. You can ask questions of the panelists by looking at your control panel, and you'll see the questions drop down box in your webinar menu. There you will be able to enter your questions, and we'll address those at the very end. And we'll also be sharing a recording of this program to everyone who is registered, so please feel free, once you receive that, to share it widely with your networks. And also please feel free to give us any feedback or ask questions to follow up. It's now my pleasure to introduce what is really an esteemed panel of litigators and advocates. You can read more of the speakers' detailed bios, but I want to share some very brief introductions. First, David Hinojosa, who is the director of the Educational Opportunities Project at the Lawyers Committee for Civil Rights Under Law. He's a nationally recognized litigator and served for over a decade as the Southwest Regional Counsel for the Mexican American Legal Defense and Educational Fund, or MALDEF. He will discuss the history of disparate impact as a legal theory in the field of education. Then we will hear from Elizabeth King, who is the Program Director for Education at the Leadership Conference on Civil and Human Rights, a coalition of over 200 national organizations dedicated to protecting civil and human rights in this country. She will discuss the coalition's efforts to protect disparate impact in education, and she'll also talk about the history of the civil rights community's engagement in protecting disparate impact. She'll close by discussing current threats to disparate impact and the potential consequences of those threats. We will then hear from Andrew Hairston, who is the director of the School to Prison Pipeline Project at Texas Appleseed. He will discuss the significance of disparate impact in the context of the school to prison pipeline. He will discuss how families and legal advocates have relied on the disparate impact legal theory to expose and to help eradicate discriminatory policies such as discriminatory school discipline practices. And we will close with Veronique Pluviose, who is the staff director for Chairman Robert Bobby Scott of the Education and Labor Committee in the U.S. House of Representatives. A former civil rights attorney and a champion of educational justice, she will discuss Chairman Scott's federal legislative efforts to protect disparate impact, including a legislative fix for the Alexander versus Sandoval case, which effectively foreclosed a private right of action to bring a disparate impact claim. So let us start with David Hinojosa.
All right, well, thank you very much. I appreciate the opportunity here from the ABA and from Janelle. I'm going to start out. I do have a mini PowerPoint that is fewer slides than minutes, so hopefully that'll be tolerable for those who don't necessarily like PowerPoint. So I want to start off because it's important to understand the difference. You know, when we're talking about, let me just move this on my screen. Oh, now I'm moved something. Sorry about that. Y'all are not seeing my screen, right? My apologies for this. This didn't happen during the practice.
Of course it didn't.
You know what I'm going to do? I'm going to just go to one screen and make this easy. Is everybody there? And maybe that didn't do it so well. I really apologize. I'm going to just go ahead and start talking. And I'll pause.
David, I think if you switch your screens, that might work, because I think this is the outline screen.
Yeah, and I was splitting this screen, but it's for whatever reason when I moved.
First time, David, if you plug your computer back in, it should be fine.
What do you see now? Are they the pictures? Is that working now?
It's the organizer view.
Mm-hmm.
The next slide.
Okay, well this is, I think, let me just go ahead and go from here. So when we're talking about disparate impact, you know, it's important to first, you know, define, you know, the difference. And so the difference between disparate impact and disparate treatment is where, of course, you know, disparate treatment is looking at intentional discrimination against a person or persons on the basis of a protected class. Normally, when we're talking about, you know, this issue here today in education, we're talking about race, color, sex, or national origin. And then when we're talking about disparate impact, it's more of something that's not, you know, directly intentional. It's not a policy that says, for example, no Latino or Black children can attend this school. It's a more along the lines of something that is not outright there, but, you know, when it's applied, it has the effect of discriminating against a person or persons, again, on the basis of a protected class, and that despite that effect, there's no actual substantial or legitimate justification for that. And before we dive, you know, directly into the history, I think it's important to, you know, have a grounding in, you know, the different laws, the different constitutional amendments that were passed. And I won't go too deep into these, of course, because this slide here itself, you know, is a subject for a webinar. But with the 13th Amendment, the 14th Amendment, and 15th Amendment, you know, the United States was really trying to sow, you know, some seeds that would lay the groundwork for more justice, especially for, you know, the Africans and African Americans who were living in the United States previously under authorized slavery across the country, but especially, you know, in the South. And so these 13th, 14th, and 15th Amendments were intended to, you know, abolish slavery, of course, bring about equal protection and due process rights as applied, you know, to the states through the 14th Amendment, and also the 15th Amendment that would, you know, allow all males to vote. And of course, that there was still some resistance that came out. You know, many of the southern states had passed what is referred to as the Black Codes. And so as part of the Reconstruction Acts, there were other laws passed, and also that required, one of the Reconstruction Acts of 1867 required voters in the districts to allow African Americans to elect delegates to the conventions that would then adopt their new state constitutions, and also require those states to ratify the 14th Amendment. And of course, as that went on, then all of a sudden there was the Plessy versus Ferguson and the Jim Crow era that again brought back a lot of overt and covert discrimination, mostly overt discrimination, where there were new laws that were enacted that were supposedly treating persons of different races, for example, the same, but it was still separate, right? So then you fast forward, half the century, we have Brown v. Board, we have other cases that came about in higher education regarding swimming pools and community parks and several other matters that were brought up, before the U.S. Supreme Court, mostly striking down many of these statutes. But there still wasn't any affirmative laws that were being passed to provide greater protection. And so then we go to Title VI of the Civil Rights Act of 1964. And even though it's not solely for aimed at education, certainly with the funding that was provided from the federal government, they were trying to use that as a carrot to help persuade state and local education agencies, among others, to abide by this mandate that no person should be discriminated against on the grounds of race, color, or national origin. And so they passed the Civil Rights Act, and with that, every agency that was authorized to provide financial assistance was to draft and adopt regulations, which they essentially adopted the same framework around the regulations that were proposed way back in the 1960s. So then as again we were talking about disparate impact, there were several cases, and this is just some of the cases that have been highlighted throughout history. Of course, again, this can go extremely deep, but when you're talking about the disparate impact theory in terms of Supreme Court cases, that's where the Griggs v. Duke Power Company case came. It was an employment discrimination case, and the question there was whether or not without overt, direct, intentional discrimination, could you still bring a case under Title VII? And there the court had said, yes, you can, when you look at the purpose of Title VII and how that falls in line with the discriminatory acts that were being challenged, the practices that were being challenged in the Griggs case. They said, yes, you can, so long as, again, there's no legal justification for that discriminatory effect under Title VII. One of the next cases that came up specifically on Title VI before the Supreme Court was a case of Lau v. Nichols, where Chinese students in the public school system in California were essentially being sunk or faced with sink or swim opportunities or lack of opportunities in the classroom to learn the English language. All the materials were in the English language. They weren't really being provided any opportunity to help transition, even though California had a law that said all of our children need to learn the English language. So the court, accepted that case, and under Title VI, it found that these discriminatory effects on these Chinese students, because it wasn't necessarily targeted directly at Chinese students, but under Title VI, they said, well, when we examine these facts, we find that Title VI, which prohibits discrimination, prohibits this type of discrimination. Unfortunately, for those who are on that side, of the argument, that didn't last very long. In Regents versus Bakke case, which was a reverse affirmative action case filed by white students against the California university system, arguing that some quotas or set aside seats for African American and Latinx students violated their rights under both the Equal Protection Clause and Title VI. The court kind of said in passing, and again, this is a case where there were several different opinions, and they essentially scribbled in the opinion that Title VI prohibits the same types of actions that is aimed under the 14th Amendment, which they had interpreted already previously, that the 14th Amendment prohibited intentional discrimination. So that statement there in Regents, even though it wasn't a big examination, there was an examination of Title VI by the dissenting opinion of Marshall and others, but it got picked up in the Guardians Association case in 1983. And there, again, there was another challenge under Title VI, and it wasn't directly on intentional discrimination, but they tried to marshal forward the disparate impact theory there, and the court came back and said no. Title VI prescribes treatment, in the similar way that 14th Amendment does, for private actors. For non-private actors, if it was the government, then you could proceed under your regulations, but not in this case could you proceed under the disparate impact theory under Title VI directly. Fast forward again to 2001, and there we have Alexander versus Sandoval, which is a case against Alabama Department of Motor Vehicles. And in that case, the state had passed a law prohibiting, or not prohibiting, but the state passed a law saying that you had to pass your driver's test in English because they had previously passed an English-only law in the state of Alabama. So for those, including those who were Spanish fluent but non-English proficient, had to take the test in English. Again, this wasn't necessarily targeted at anybody's national origin or race, so they had to go under a disparate impact theory and say, well, the effect of this is to discriminate against people based on their national origin, which has been linked to their ability to speak English or to speak another language. And that one was filed trying to enforce the disparate impact regulations that were authorized under Section 602 of the Civil Rights Act. And the court came back and said, no, there is no private right of action to enforce those disparate impact regulations. And that law was allowed to stand despite that ruling. I'm only going to briefly do, I think I have maybe, about a minute or so, but there are different ways, to still use disparate impact. It's important to understand that the door hasn't completely closed. Of course, you could still go to the federal government and file a claim for those who do Title VI work and complaints on behalf of individuals or communities with the Department of Education, for example. They're not always the fastest, whether they're trying to complain about disparate discipline, disparate access to gifted and talented, and so forth. It's still certainly a vehicle to use. It just isn't always the fastest vehicle that can get you there. But beyond that, if you have an outstanding desegregation order or compliance order under either Title VI regs or under an actual case, such as there are still many desegregation cases, then disparate impact still is looked at as an individual legal theory to continue oversight. And there's still universities that may still be under some of the OCR reviews that were ordered, way back in the 80s and 90s and continuing to the present day. There's the Equal Educational Opportunity Act for language discrimination. State constitutions sometimes authorize, greater protection. In New Mexico, for example, their Equal Protection Clause has been interpreted as being and meaning broader protection. So those are certainly things that you can look at. You can also look at state laws that might be similar to Title VI and providing those protections. State agencies also enforce various regulations and laws. And then there's also theories around Section 1983 to use. So Section 1983, again, another whole full day course on this, but very quickly, it's a vehicle, right? You can't bring a cause of action, a Section 1983 cause of action. It's a vehicle to get you there. So the theory in some of these cases and the success varies by circuit. Some have been, successful in arguing this, but essentially that the regulations have been so substantial, authorizing, the disparate impact under Title VI, that it's created, its own cause of action and the legitimacy in affording rights to the people under the Constitution and laws. And as such, you can use Section 1983 to try and push those forward. So that, in a nutshell, is the history of disparate impact. Thanks very much, and I appreciate it and look forward to the questions.
Thank you so much, David, for that historical context. That was very rich. And then also for letting us know that there are still avenues that folks can take to address discriminatory practices and policies. Next, we'll hear from Liz King with the Leadership Conference.
Thanks, Janelle. Yeah, I'm Liz King. I lead the Education Equity program here at the Leadership Conference on Civil and Human Rights. As Janelle mentioned, we are a national coalition of national civil and human rights organizations, as well as some allied organizations, all working to advance civil and human rights nationwide. So, David talked a lot about the litigation side. Obviously, the civil and human rights community has been engaged in advocating around discrimination in all of its forms for many years. I mean, the laws that he is talking about were the result of advocacy by civil and human rights advocates in communities. Their enforcement, so, we get the Brown v. Board of Education and the failure to comply, which was illuminated by advocates in communities, pointing out that there was a need for additional legislation. And then you had advocates pushing for the passage of that legislation, pushing for regulations related to that and enforcement, and that ongoing advocacy by the civil and human rights community to ensure compliance with and enforcement of our federal civil rights laws continues today. And I think it's just important that we never lose sight of these advocates and communities are always the ones who have been making this the most real, and that, I think we are all thankful for the litigators and the lawyers who are the ones who bring it into the court, but that can't happen without people in communities pointing out what's happening and standing up to demand that their own rights be protected. So David talked about, litigation and the ways in which Sandoval has undermined our civil rights laws and hampered a critical tool that has been important for ensuring that people are protected from discrimination. And I think that, we are thinking about this not just in the context of Sandoval and in the context of education and the context of disparate impact and Title VI, but thinking more broadly about the ways in which people experience discrimination today. So this idea around, the distinction between intentional discrimination and those things which have the effect of discriminating, I think, a lot of what we're thinking and talking about is the need to be responsive to how people are experiencing discrimination, and that there is a intentional and concerted effort to narrow the concept of discrimination and basically to exclude the ways in which people experience discrimination now, and to relegate discrimination as a thing that only was manifest in the intentionally discriminatory laws of the 50s and 60s and beforehand. As David has mentioned, the discrimination that we have that we live with, that people experience today, is very much rooted in a system of laws that had been put in place for hundreds of years. And so the question is, you know, in what way and to what extent are the laws that we have today undoing the system that was created by the laws of previously, and how is that manifesting itself? So, you know, the other thing I just wanted to make sure, you know, in addition to keeping in mind the ways in which the civil and human rights community has been out here advocating, that people in communities have been fighting for their own rights and have been illuminating the problems that they're experiencing, the ways in which their opportunity is limited by discrimination, is the ways in which all of these experiences of discrimination intersect. And, you know, we think a lot and talk a lot about race, color, and national origin, but also thinking about where disability and sex, including sexual orientation and gender identity, fit together in people's experiences of discrimination. And we know that when there is a threat to, or an effort to narrow avenues for redress with regard to one type of discrimination, it is symptomatic of a larger problem. And it is never the case that it is narrowed to one community or one particular experience of discrimination. And, you know, Andrew's going to talk a lot about school discipline, and we think a lot about disproportionality in the context of school discipline as it relates to race, but we know there also exists disproportionality at the intersections of race and disability and race and gender. And so the need to think of the ways that people experience discrimination very much as interrelated. So just a little bit about the threats that we're seeing right now in terms of national, federal policy really is an effort to enforce what was an agenda under Reagan and in the 80s to dial back the winds. So we saw significant victories by the civil and human rights communities and the allied lawyers in the 50s and 60s, not only to get these laws passed in the first place, but to get regulations that made them meaningful and enforcement that made them meaningful. You know, ever since that happened, there has been a resistance to that and an effort to undo those victories. And so that continues today. The manifestation that we hear today is an effort to narrow the understanding of what is discrimination and to delegitimize disparate impact as an appropriate understanding of people's experiences of discrimination. And, you know, that comes in the context of a political desire to rewrite regulation, to reopen laws and narrow definitions. And Veronique is going to talk about some of the legislative remedies that are being considered to some of the barriers that have been put in place by the courts, but then related into all of this is sort of this larger agenda around denying people's experience of discrimination, marginalizing that experience of discrimination, and legitimizing that, you know, arguing that because there is not evidence of intentional discrimination, that what people are experiencing is not in fact discrimination, even though by any reasonable definition that's going on. So this is something the civil and human rights community has been advocating around in a concerted and a coordinated way. You know, in this specific webinar, we're talking about education and the ways in which disparate impact is a critical tool to ensure equal educational opportunity. But I think there was a previous webinar where, you know, the context of housing was discussed as well. And there are obviously different facets of people's lives where they experience discrimination, and that there is a need for disparate impact legal theory to protect people from that discrimination and to remedy that discrimination when it happens. So we just wanted to share that. I'm happy to take any questions, and we'll turn it back to Janelle.
Thanks so much, Liz, for that rich discussion and overview. And next we'll hear from Andrew Hairston with Texas Appleseed.
Good afternoon, everyone. It's such an honor and pleasure to join this esteemed panel of advocates and litigators. So yeah, as Janelle expressed and as David and Liz teed up, this has been a very important tool for us in the civil rights, education, justice community, disparate impact in addressing the school to prison pipeline. Just to give a 30,000-foot view definition of the pipeline, it can be summed up as a very intentional racist system that has been kind of the culmination of zero tolerance policies that have been put in place over the past 30 years, both by the federal government and state and local governments, using exclusionary discipline and school policing to push out young people who have historically been underserved, Black and brown students, LGBTQ young people, and kids with disabilities and really leads to entanglements with the criminal legal system for fairly routine age-appropriate behavior. And so in thinking about disparate impact, Texas Appleseed a few years ago under the Obama administration looked at this community called Bryan, Texas, which is about 100 miles northwest of Houston. We were receiving calls from parents in this community about some really alarming disproportionality in the discipline being administered to young people, and decided to collaborate with the NAACP Legal Defense Fund to file a federal Title VI complaint with the Department of Education's Office for Civil Rights. So, under the Obama administration, I think there was this understanding that when you have statistically disparate results that come with school discipline, especially in spaces across the Deep South and other regions of the United States, you can say that, look, there are 20% of Black students represented in the school population, but perhaps 60% of these arrests and referrals to law enforcement being Black children. And that could be an avenue to strengthen some of the Title VI complaints that were filed even just several years ago. And so we filed that complaint in February of 2013. That unfolded. Usually OCR might have some type of 180-day timeline where it receives the complaint, evaluates it, goes through its internal processes, and then tries to issue a result. But certainly with some of these civil rights complaints and under the guidance of the Obama administration, there was a willingness to evaluate some of those deeply entrenched racist policies as they had played out over years. So the complaint remained active for a few years up until the election of 2016 and soon after the Trump administration took place. So there's this kind of dual approach that emerged under the Trump administration, the idea that getting back to this idea of evaluating complaints quickly and efficiently would be in the best interest of advocates, to be timely and efficient, as they would say, and to really try to decentralize the evaluation of these complaints from, the DC office to the various regional offices across the United States. For example, Dallas is the regional office for OCR, for Texas and Louisiana and a few other states. So that combined effect led to, with the Bryan ISD complaint, first, a narrowing of what was examined in the complaint. The folks from OCR reached out to us at Appleseed and to LDF and to the folks we were representing to say that they would only evaluate the issue of police ticketing of young people, which, one case, I highly recommend this ProPublica article that came out in April 2018 that really gives a full and thorough examination of this complaint and other issues in Bryan. Yeah, with that correspondence in early 2017, OCR said, well, we're just going to evaluate police ticketing, even as this young man, D'Angelo, who was mentioned in the ProPublica article, moved to Bryan in 2010 and almost immediately was targeted and really had these negative experiences with the police officer on his campus and kind of continuing this wheelhouse of discipline. And then in September 2017, the department came back and said, well, we're going to close this complaint. It looks like there's not sufficient evidence of discrimination as we have defined it. So I think it demonstrates a few things, as Liz and David were discussing a bit earlier, the idea that discrimination is trying to be redefined as perhaps this person-to-person thing, right? That, and even if it's not person-to-person, it has to be this like very direct and intentional, I called you a racial slur, or you use some type of derogatory language to make you feel unsafe. as opposed to the discriminatory effect of school policing or exclusionary discipline being examined. And then it has just really empowered, I think, school districts and policymakers to say that, oh, well, there might be some discrepancies in how discipline is administered, and Black and brown children might be feeling the brunt of this, but this kind of goes with the administration of the school, and we're trying our best, but we can only do so much. And they have gotten somewhat of a rubber stamp under the current administration to say, well, yeah, we can use that justification. One thing that stood out from the Obama administration's approach was that these statistically disparate results could create a presumption of discrimination that the school district would have to rebut, and that school district would have to offer a legitimate educational justification for the disparate results under that framework that was adopted. And these days, it's that much easier to come up with the legitimate educational justification, especially in the era of school shootings and conversations about school safety, right? Especially in that realm of school policing, to say, oh, well, it's unfortunate that Black children represent 60% of the ticketing and arrests that are going on, but we're trying to justify the ongoing presence of school police officers on these campuses in Bryan and elsewhere in Texas and elsewhere across the U.S. for these very nebulous definitions of school safety and ensuring that. And so it's something that has been difficult for us to navigate, I think, in the education, justice, civil rights community. Title VI complaints were a fairly popular avenue under previous administrations to explore, to really demonstrate the systemic level of the school to prison pipeline. But under this administration, it's caused us to adopt more creative approaches and think about how exactly can we preserve some of these good decisions that were made in the OCR iterations of years past, and how can we really demonstrate that, as Liz was talking about, these intersections of oppression, especially as the school to prison pipeline continues to play out, are very real, and young people are going through these really heinous treatments by their schools and these school police officers in real time. So yeah, again, I highly recommend that ProPublica article. I think it's very illuminating. And I also forgot to mention, feel free to tweet me at Andrew R. Hairston if ever you like during this webinar just want to talk about education, justice, and the civil rights space. I'm very, very active on that platform.
Thanks so much, Andrew. You do have a great Twitter feed, by the way. I think we have a hashtag for this series. I think the hashtag is Ed in Democracy.
I love it.
Thank you so much. And next we'll hear from Veronique Pluviose, Staff Director for Chairman Bobby Scott.
Hi, everyone. Thank you so much for this very important discussion. And I will be brief because I don't want to have to be to repeat what everyone has said, but I will look at this from the perspective of what we're attempting to do in Congress based on the illustrious work of my colleagues on this panel. In the last 3 Congresses, and I'm going to try not to speak Washingtonese, but rather I would say since 2016, Chairman Scott has introduced a bill called the Equity, Inclusion, and Enforcement Act. For this Congress, the 116th Congress, the bill number, for those who are interested in looking it up, is HR 2574. HR 2574. It's a very short bill. It's a 4-page bill. And the bill essentially is attempting to restore the right to private action, essentially to correct the Sandoval decision, which David went into detail about, but everyone has talked about. Essentially, the bill is attempting to push back against this rising narrative that in order to prove discrimination on the basis of race, color, or national origin, that essentially the case can be shown only if it's a direct claim. Essentially, someone would have to hurl, or in the context of education, say, we intend to deprive these students equitable funding for advanced placement classes because of race, color, or their national origin. Or we will have a practice where Black, brown students who are using their cell phones in class will be disciplined because they are Black and brown. The reality is this is not how most acts of discriminations are carried out. Sadly, there are people who think they can still do that. But with the advent of the Civil Rights Act, of which Title VI is a part of this very, very critical federal law, we have moved away from requiring this direct purpose, stated purpose of discrimination, and instead Title VI allows us to deal with the realities of the situation, which is really highlighted in the context of education with some stats I'm going to provide to you that justify why it is we introduced this legislation. So I mentioned that it essentially is allowing for the private right of action. Really, the main reason for us is that it's not that the Sandoval decision said you can no longer bring in disparate impact claims. Rather, what the Sandoval decision really inhibited us from doing is bringing a private right of action. So that is, if you do not have the group like the MALDUS or the NAACP Legal Defense Funds or the Lawyers Committee, someone with deep pockets who can then negotiate on your behalf with a friendly federal government or state actor to bring the lawsuits on behalf of an aggrieved party, the chances of individuals being able to bring these lawsuits to stop at these disparate impacts cases, and especially in the context of education, is slim and none. You know, these cases are expensive. They're difficult to prove. When you don't have something that says student X is being denied because of their race, color, and national origin, you have to employ experts. You have to employ someone who's going to go and dig into the history of the practice. Who are the actors? What did the minutes say? Who are the participants? Why did the policy get established, or why is it continuing? All of these require deep pockets that governments may have, organizations may have, but individuals cannot on their own bring without having that force behind them. And so one of the things we were attempting to do is deal with the realities of that. The bill also does a couple of other things, such as it creates a assistant secretary at the Department of Education so that we can have someone at the Department of Education that's specifically providing technical assistance to schools, to local educational agencies is how we really address them, because they address all kinds of educational agencies, to inform them of how it is they should have policies and practices that do not have disparate impacts on the basis of race, color, and national origin. The other thing that the bill does, again, to address the disparate impact of policies and practices that occur in schools, is to ensure that the schools have what we would call Title VI monitors. And this is, for those of you who operate in the education space, you may hear of Title IX coordinators. Well, a Title VI coordinator, excuse me, it's coordinator, not officer, but a Title VI coordinator would essentially act like a Title IX coordinator. That is, they would be the individual that is assigned by each local education educational agency or school to ensure that the school's policies and practices are in fact being carried out in a way that it doesn't have a disparate impact on the basis of race, color, or national origin. So I mentioned that in the last, since 2016, we've introduced this bill led by Chairman Scott and then Mr. John Conyers of Michigan, and most recently in his new position, it's Chairman Nadler of the House Committee on Judiciary. The bill was voted out of committee in May of 2019 to observe the anniversary of Brown v. Board of Education. And we did this somewhat symbolically because while many people only remember Brown v. Board of Ed because it obviously struck down de jure segregation, which is the explicit, like, we don't want Black children in this school. We also thought it was symbolically important for us to pass this disparate impact bill at this time to remind people that depriving students of educational opportunities also occurred in many, many other parts of these United States that did not have the express de jure segregation laws, but in fact was discriminating on, with a policy and practices to have the effect of discriminating on the basis of race, color, and national origin. When we were marking up the bill in committee, I would note that there was a congressman on the committee from Kentucky who did actually attempt to strike the bill's language from restoring specifically the private right of action. Oftentimes, the expression is that these lawsuits are simply being put in place to feed the Trial Lawyers Association, to have lawyers get rich. I have yet to meet a rich civil rights lawyer. But if anyone knows, I'm single and looking. But in all fairness, it's not something that is the reason why people do civil rights work. It's also when you are dealing with the victims of such discrimination, whether they are based on race, color, or national origin, the harm is often very real, and it is not something that people claim because they're looking for a lucrative payout. And needless to say, given the new committee's majority, given the change in the majority of the House, we voted that provision down. I think it's fair to say that when we had our multiple hearings over the series of years and roundtables on this issue, we were able to bring up why this was necessary, primarily driven by the racial inequities that exist in our public school systems. We've had multiple studies. For example, there continues to be, as most recently in the 2019 National Assessment of Educational Progress, reveals that the achievement gap is actually widening. And why is it widening? Because we still have instances where the graduation rate for Black students is 78%. And while that is improving from where we were in the hardcore days of Jim Crow, the fact of the matter is increasingly over the last few decades, since the 1980s, and there's a reason why this stuff started again in the 1980s, we have seen an increasing in the educational gap. And in part, it's also because of nationwide shows that 40% of Black students and 41% of Latino students attend intensely segregated, high poverty schools. And that is something that was found by the Government Accountability Office. In other words, GAO found these. We know that this is happening because many of these schools have fewer resources, less access to math, science, and college preparatory classes, including AP courses. And the reality is we have students disproportionately expelled and suspended and even held back at these alarming rates. And we know disproportionately and disparately on the basis of race, color and national origin. And this is true where the students are similarly situated. And that cannot be dismissed. And that is especially glaring when we look at school discipline issues, where similarly situated students are treated differently. We also know that research from EdBill shows that school districts that serve students of color receive $23 billion less than school districts that serve similar numbers of predominantly white students. Again, these are not because the policies say, let's treat the white students differently than the Black and brown students, or the students who attend, who mostly have ESL students, English for whom English is a secondary language or third language. That is not the express policies, but nevertheless, these are what the patterns, this is what the data, and this is what the evidence shows. And so it would behoove us to have a legal situation where we are not providing tools to those litigants to go into the courtrooms to at least plead their case and see what's happening. The other thing that was made clear was in 2018, GAO came out with a report that shows that schools, because driven primarily by bias, discipline Black students generally, boys, and students with disabilities at disproportionately higher rates, and that Black students in particular are subjected to harsher principles than their white counterparts, regardless of income. And so there are many people who are like, well, poor kids, that's what's happening here versus rich school districts. And yet the common denominator that we find are the basis of Title VI to begin with, which is race, color, and or national origin. And this is the kind of data that we found not only in the K-12 space, but we're also seeing that play out even in the higher education space. And this is happening at a time when studies are showing since 2016, there's also an elevation of the rise of hate crimes reported on college campuses and just generally hostile school environment, both from the K through the higher education cases. Again, there are no policies that says to treat students differently, but students are showing up to play a competition where they're being told, go back to where you came from, subjected to chance that says build a wall, et cetera, et cetera. And oftentimes what we're seeing is the discipline that is taken when in terms of who's engaged in that behavior by some of the universities and indeed the K-12 space differ depending on the race, color, and national origin of the students. And so that is why we attempted to not only restore the private right of action, but also require that the Department of Education create a position for an assistant secretary to actually create an office to advise schools on how they should be complying with Title VI, which, by the way, is not a new concept because there is also an assistant secretary for Title IX coordination. And the final thing that the bill does is it provides for each of these institutions in the K space all the way to post-secondary to have such a coordinator so that those schools can have the technical training and expertise to see how in fact it is properly implementing Title VI to ensure that kids are not only attending schools, but that they're doing so in a safe learning environment. Thank you.
Thank you so much. This has been such a great discussion. In particular, the emphasis on this distinction between intentional discrimination and the reality of how individuals actually experience discrimination, including through intersecting identities as well, I think is so critically important for this discussion and for overall understanding of disparate impact and why it is such a significant legal theory. And why it's something that we must work to protect. I will remind not callers, excuse me, I will remind the attendees of the webinar to please submit questions via the question panel. It's right in the control panel, and if you click to the left, you are able to enter your questions in that box there. And let me see, I think we have one question that we'll start with. And actually, before I get to that, I just want to, again, thank our panelists for their time, for their input, and for just a great perspective they provided. So our first question, it starts with saying also a thank you. Thank you for this wonderful exchange. And the person notes, I was disturbed recently seeing a video posted by Guardian 2, I think this was on February 25th, where a 6-year-old, Kaya Roll, and I also believe she was a special, I'm sorry, Veronique, how do you pronounce her name?
Oh, no, I was remarking
this video, okay.
Yeah.
Yeah, and I think this was on Twitter. This was trending on Twitter as well. And I think she was a special needs student too. Was being arrested by a police officer for kicking a teacher while experiencing a temper tantrum in Orlando, Florida. I looked up the minimum age in Illinois for detention and learned that it's 11 years. Also in Illinois, to sentence a minor to a juvenile state prison as opposed to detention after trial, the age is 13. Juvenile detention centers are the equivalent of adult jails, and law prescribes youth can be kept in detention for 30 days. What, if any, are there any attempts to address that? For those of us who are in higher education and teach law and society courses, how can we begin to explain legislative action to end policing of children and using child detention as a behavioral corrections measure, particularly considering that these children come from lower income backgrounds and are often students of color. Veronique, you touched on this at the end of your remarks when you pointed to some of the statistics, and Andrew, you obviously touched on this as well. So I'll direct that to you two, and then definitely if David and Liz want to weigh in on that as well. But I'll start to open that to Andrew and Veronique. Thank you.
Thank you, Janelle. Veronique, would you like to go first?
And that is that you want to talk about the disparate impact, I'm sorry?
Yeah, school police.
I think it's overall the
school policing. So the just to be clear, this particular bill, HR 2574, does not address the school policing issue. However, when we wrote the bill, we definitely wrote it in mind with the understanding of how school polices, sometimes called school resource officers, they go through various different iterations, are essentially employed by too many schools to essentially contribute, as best as I can see it, to what is, I think now politely referred to as the school to prison pipeline. You often have, in many of the recent cases that have really exploded in the media in terms of informing us of how widespread some of these problems are, we too often have seen instances where some of these school resource officers were not either previously fired from local police departments, but in some instances were didn't make the cut, if you will, for either psychological profile, temperament, or a whole host of other things. But the schools are able to hire them on the cheap. And then these in schools now are having these police officers who sometimes don't look anything like the students that they're policing. And they are now engaged in a situation where behavior that is perfectly normal, although annoying as a parent, and as a parent of grown children, I understand what it was like to go and see a 6-year-old have a complete meltdown and have a temper tantrum, or God forbid if any of us engage in what used to be a fight in school. not something that our parents necessarily encourage or some of us wanted to do, but there were behavioral systems, mechanisms that used to occur in a school or we used to apply that we are now having school systems export to be handled by school resource officers, school police officers, and very quickly what used to be the kind of behavior that used to be frowned upon by any society, kids shouldn't misbehave, are quickly escalated to being addressed through the lens of the criminal justice system, or really a penal system. And as a result, you're feeding this pipeline where, you know, fights in school, fights after school, food fights, melting temper tantrums, talking back to teachers are now being seen through the lens of I fear for my life, and therefore I'm taking this kid in handcuffs. But what is telling about it is that GAO's own studies show that this is happening even when you have white students who are occurring and who are exhibiting those same exact behaviors. But because of people's biases, it's being perceived differently. And this is where the disparate impact analysis is important. And this is why the private right of action to look at such analysis is important, right? Which is, it is, I am 100% certain that the schools do not have it written down anywhere that you should treat student X differently from student Y because of race, color, and national origin. But humans being humans, we are driven by biases. We are driven by a whole host of other emotions. And as a result, some of what would seem as benign behavior starts to rear its head in practices and policies that not only disparately are impacting one group of students, but they have detrimental effects that last beyond just being sent to the principal's office, which is what may have happened in the 1970s when I was growing up, but rather what you may now have is a police officer literally dragging a 6-year-old in tears saying, please don't handcuff me. And that is something that requires us to step back and say, what was the school thinking by having a police officer, A, handling a kindergartner, B, handling a kindergartner in that fashion, and C, seeing that there's nothing wrong with that policy, that they are instead standing by and defending it. And what is the recourse to that child and the children around them who very probably look exactly like that young student? And what does it send to those students? And what does it send to that entire community? And what right of action, what recourses does then that community have on behalf of that child? Especially in a time and a place, and I have the stats where I can rattle off, where we know we are currently under an administration that is not only not bringing these cases forth in the courts, but they are dismissing them and they are rolling back the kind of guidances and technical assistance that they used to provide the schools so that those schools would not engage in those kind of behaviors.
Very much so. Veronique, is there a bit of echo? Can folks hear me? Okay.
Yeah, yes.
Okay, perfect.
Thank you.
Yeah, 100% everything Veronique just expressed. So I'm an alum of the Advancement Project's National Office, and about a year and a half ago, that organization, along with the Alliance for Education and Justice, published a report called We Came to Learn, which is an explicit call for police out of school across the United States. And it really was a culmination of research and anecdotes of folks over decades recognizing that as zero tolerance policies have become more entrenched in schools, and as there has been a proliferation of the presence of police officers in schools, it's been the zero-sum game for Black and brown children, LGBTQ young people with disabilities, where police officers really are acting with impunity on their school campuses and where these historically underserved groups of students are experiencing the worst harms. So in moving to Texas 9 months ago, I tried to take that political orientation with me, and I'm always thinking about how to operationalize that call for police-free schools. I think that was an egregious and heinous video that folks are seeing on their social media timelines and in the news. But I think it's far too common, right? I think something like what happened to that young girl is happening probably almost on a daily basis. I wouldn't be surprised in communities across the country. So going back to the point that Liz made, I think, as a lawyer in this space, and, as someone who has kind of come up and raised for justice advocacy over the past 5 years, I'm always trying to be a movement lawyer and really be of service to the community and uplift those directly impacted parents and young people who are experiencing the worst harms of these systems every day, and just trying to lend my voice wherever possible to uplift their effort, knowing that, like as with the civil rights movement in this current moment of American history, that organizing from directly impacted people is going to be what delivers, I think, freedom and justice and equality. So, the call for police-free schools feels more and more salient with each passing day. I think there are many complications, bringing it back to this conversation around disparate impact. Not only do you have the difficulty of really demonstrating the discriminatory effect in a court of law or in a state or federal education complaint, but you also have this culture around policing where it's like, well, we defer to what they do. They had to act with this split second decision mentality in mind, and they can drag the 6-year-old child across campus while she's crying and screaming with impunity. So I think more and more conversations just need to be had about it. Even in my Twitter, some encouraging reactions, calling for police-free schools, saying that this is something that has been going on for decades, if not centuries, and having more and more of that conversation in the zeitgeist, I think, can really some strong wind to this call, and really say and call it explicitly what it is, just the old-fashioned American racism, and it's something that needs to be addressed head on.
Thank you. Thank you both for.
Yeah.
Oh, Liz, please go ahead.
Yeah, no, Janelle, just kind of to add to that and to name the resource again that Andrew had talked about, the We Came to Learn report. So definitely encourage folks to take a look at that. Another resource I would point people to, our coalition came together and developed principles for safe, healthy, and inclusive school climates. And these are principles that are meant to inform federal legislation. We're talking about disparate impact, which is a remedy once discrimination has occurred. What happened to that little girl has now already happened. And so we all have to figure out what justice means for her now. But what we know is that systems failed before that happened to that little girl. And so what are the proactive things that we need to make sure are in place in our schools so that every child is going to school in a learning environment which is safe, healthy, and inclusive. So encourage people. Our website is civilrights.org, and that resource is available there, the Civil Rights Principles for Safe, Healthy, and Inclusive School Climates. A couple of other things I just wanted to name. Andrew had mentioned the way in which school climate, or school safety rather, is being used as a pretext, as an educational justification for a lot of these new policies and practices that we're seeing. Florida, I think, is ground zero in a lot of ways for the pretext of school safety, is making children less safe. And obviously discrimination is a way in which children are made to be unsafe in schools, whether that's discrimination based on their race, disproportionately, of course, Black children and Native children, or on the basis of their disability or the fact of their lives at the intersection, Black children with disabilities, Native children with disabilities. Another thing I wanted to lift up in that context is what we're seeing around threat assessment, quote unquote threat assessment. Starting from the presumption of a child as a threat, we can imagine, we know the research is unambiguous that the behaviors of some children are perceived to be threatening when those same behaviors by other children are not perceived in the same way. And the ways in which the procedural rights of children under the IDEA, children with rights under IDEA are being trampled upon and being disregarded in the name of threat assessment, in the name of school safety. And so this presumption that for the protectual safety of some is to eliminate the rights of others, and just wanted to make sure people were aware of that. But encourage folks to check out the We Came to Learn report, as well as the Civil Rights Principles for Safe, Healthy, and Inclusive School Climates. We really do need to work together to advance policy and legislation that will proactively ensure that children do not have these experiences of discrimination, while at the same time we're ensuring that the remedies are available when the discrimination does occur.
Absolutely. Thank you. I do want to note, someone noted in the questions, this is more of a comment, that State Senator Randolph Gracie in Florida filed Senate Bill 578, which would prohibit law enforcement from arresting children under the age of 11. So just want to flag that. And it's a shame that, you know, that's even necessary, but it is. Also another question, this is related to, it's not so much a technical question about union contracts, but it's just a point about this. Most union contracts protect teachers from physical abuse. Who will begin this discussion with teacher unions and administrators to redevelop the kind of policies and language that are included in the contracts?
Well, if I can take a stab at this, the reality is that the Department of Education was actually providing grants to a number of schools across the nation that was implementing desegregation programs, that was actually seeking assistance on how to improve not only the equitable distribution of resources in their schools, but also to do so in a way that kind of cut the vestiges of segregation. That was happening until this administration that literally took away and eliminated the funding for this. And so as a result, we've had to introduce another bill called the Strength and Diversity Act for those schools that are already voluntarily engaging in programs to desegregate their schools and to make their schools more equitable. And I answer that particular question that way, in that if this is not about what teachers unions or one group, the police or whatever, if we do not have an understanding of what discrimination is, how it can play out both intentionally and unintentionally, and that we should have a U.S. Department of Education that should encourage schools to do so and not take away the grants and the funds to try to learn. And in fact, we should be encouraging, offer more carrots for those schools that are learning and incentivizing. And where those schools are refusing to learn, then we can come in with a stick approach if necessary. That's where our focus should be, so that we don't have a solution that is in the form of, as Liz said, reminded all of us, that we're now addressing the problem after the harm has already been instituted, or the response comes in the form of, well, you can't put kids under 11 in handcuffs. We're fixing everything around the situation if we're not really addressing these vestiges, whether it be from vestiges of slavery, of Jim Crow, of the institutionalized prejudices that we've had existed in the Southwest against certain groups of color. It is, you know, we've got to look at it and understand the intersectionality where it does disparately impact kids who are disproportionately getting identified as special needs kids, problem students, and then we don't provide them with the resources. And then when they are misbehaving, we then chuck them to the criminal justice system. That's what we should be encouraging on, and not necessarily looking at, you know, whether the teachers union provides for this, or it's not the exemptions that has created this cesspool of problems where we are literally dealing with blind eyes to this policies and practices that disparately impact on race, color, and national origin.
Thank you so much, Veronique. I just want to flag, someone just shared that in Utah, Representative Sandra Hollins has passed House Bill 460. This was passed in 2016, requiring school resource officers to have training and clear agreements, MOU, memorandum of understanding, that define the role of police in schools versus the role of administrators, the goal of which is to decrease police involvement in school policy violations. Another point that, sure, David.
I just wanted to comment on that because I'll put my hat on as former Region 2 Equity Assistance Center. So the federal government funds, you know, equity assistance centers, and we certainly appreciate Chairman Scott's leadership and support of that. But I led the Equity Assistance Center that was helping serve school districts all across the old American South, minus a couple of states. We had 11 southern states plus Washington, D.C. So from Texas up to Tennessee, down to Florida, up to Virginia and Washington, D.C. Very tough area for students of color, especially in the area of discipline. And some of our work, we would respond to complaints to the Office for Civil Rights, and they were investigating. Sometimes there would be compliance reviews, and we weren't necessarily doing those compliance reviews, but as part of the compliance orders, we would go in there and provide training. We would also do some investigation prior to the training, so we knew what some of the underlying problems were there. And this happened more than once, but I do recall, you know, it could have almost been a case study with some SROs that we were responding again to disparate school discipline practices in a North Carolina school district. And we were interviewing, you know, administrators, principals, central office, school district administrators, and several others, teachers and students, also students who were being disciplined. We did a really thorough analysis of this, but as part of our work, we were interviewing some of the school resource officers. They came from different backgrounds, different races, you know, very, you know, diverse group of officers. And it was just fascinating about the way that some of them thought about this. Now, I wasn't doing a deposition, you know, I had to leave my litigation hat outside, but we had, you know, some important questions to ask of the panelists, of the SRO folks, and we were just in a circle, kind of informal, but we were asking questions about, you know, kind of around what their philosophy was. And some of them were like, well, I'm a law enforcement officer. My job is to enforce law and order. You know that, so, and I was like, well, so what triggers you, you know, approaching a student? And he's a violation of any law. Any law? Any law you feel that, you know, someone being too loud, you can approach that person? Yes. You know, and there were other officers who were looking at him like, whoa, wait a second, you know, that's not how I do it. And these other officers were like, well, wait a second, you know, I'm here. Yes, I'm a law enforcement officer. I don't, you know, forget that. I don't put down my badge, but I'm also in a school.
Yeah.
I'm not on, you know, the streets, you know, fending off, you know, whatever, you know, they might feel, you know, what dangers might be there. But I'm in a school, and this is a place for education first. And so my job, you know, and especially if I want to do my job well, I need to build relationships with these students.
Yes.
They need to learn to trust me, because every once in a while, I mean, they were still being a little smart about this as a law enforcement officer. You know, they need information from the students, but they really felt that if they built these positive, healthy relationships with the students, the whole climate would improve. And then when you talk to the principals at these different schools, you can kind of see how their leadership feeds off of what kind of discipline is going on in those schools. And some of the officers don't realize about how all of a sudden their presence can escalate things. And this goes back to the teacher question. You know, some of the teachers don't realize they just get tired of a student, so they call they just call the principal, but the SROs listen in on the radios, and then they show up. Some of them would show up. Some of them would be like, no, I wouldn't go to something like that. And then all of a sudden they see and they're starting to interact with, you know, the situation. And sometimes all of a sudden just their mere presence escalates it. I'm like, well, do you understand how, you know, this person's having a disagreement with the teacher? Maybe it's about the way that they're teaching or something of that nature, but it's just a disagreement like that. Now all of a sudden you show up and you have your badge. Sometimes, you know, they had their handcuffs, you know, and other things showing there. And now all of a sudden everything's escalating. I'm like, you don't know the experiences of these students, you know, what happened, you know, in their communities, what kind of relationships they have with police, whether or not they fear them, et cetera. Now all of a sudden you've escalated the situation. And it was interesting to see some of these officers, you know, responding, because some of them were like, well, heck, I don't give a damn. Others were like, wow, I never really thought about that. You know, and the teachers too, when we were interviewing the teachers and the principals, you know, they didn't really think about this. I just mentioned that because it is so incredibly important. Not that they just receive training, because some of them do receive training from other officers, but that they see the right training and that it goes in depth and it helps change their practices and their belief system, so they can really, if they have to be there, then they can at least do their job most effectively to make sure that the students, you know, are kept safe.
Thank you so much, David. I do want to flag a follow-up to that question that I think is really important as well. The notes from the union perspective, when the school system policy requires teachers to call in external support to their classrooms and not touch the child, they are restricted in their response as they are then fired. So the discussion must go to how to change a policy at the school classroom level. And I think, Veronique, this is what you were emphasizing, which will then speak to the biases, the larger bias. And I think that this was mentioned too in the framing. This is not just individual bad actors. When this kind of discrimination becomes systematized, this is what happens. This commenter notes a law enforcement angle takes on another issue. David's comments are speaking directly to that issue, so thank you for that. One other comment, I know we have a little over 5 minutes, or one minor question is given the step back on federal enforcement. And David, in your opening, you talked about some of the different avenues in the absence of private right of action, which the Chairman Scott's bill is trying to restore for us. But in the absence of the private right of action to bring a disparate impact claim, you pointed out some of the options that are available, including relying on state constitutional language, state laws. Section 1983 is an avenue, the Equal Educational Opportunities Act. But given the step back on federal enforcement, is reliance in filing a complaint with a federal agency a viable strategy? Or, as Andrew mentioned, it should be really focused much more on community advocacy and community efforts to address some of these issues. So I will open that up for our last few minutes.
Yeah, I'll just go first and try to be brief, as a lawyer can try to always be brief. It has to be parallel efforts all the time. You know, when I brought a intentional discrimination case, a segregation within the school, it was called Santa Maria versus Dallas ISD back in 2006. So there was a school segregating students using ESL as a proxy to segregate African American and Latino students, right? You know, we proved that incredibly high bar for intentional segregation, but even in that case, we still had to have, you know, parallel efforts to make sure that the community understood what was going on and what they needed to watch out for when and if, you know, we had ended up leaving the case. That happens in almost every type of major systemic case that you're doing, whether it's, you know, school finance reform or school desegregation. You know, this always has to have a parallel effort of, you know, making sure the community, because the community is going to be there. Once the lawyers leave, the community is still going to be there, and they have to have, you know, that buy-in. So I'll just leave it at that. Thank you.
It's very eloquently put. I agree. I think there always has to be that parallel effort and the idea of movement lawyering and being in touch with the community as much as possible, and really using the efforts that are available to us as lawyers, whether litigation or policy advocacy, to bolster the efforts of the community is just quite necessary in this moment in the United States.
Veronique?
Your mute might be on.
Yeah, I think can you unmute yourself, Veronique?
Okay, there I am. Sorry, I wanted to add to both what David and Andrew said, and Liz touched on this earlier, is that this really does require a holistic approach. But I would stress that we actually, in our hearings, when we heard from the experts, we didn't hear primarily from litigators. In fact, litigators were not whom we primarily heard from. We actually heard from teachers, we heard from parent organizations, we heard from school board associations and whatnot. And what they actually told us is that they're actually looking for guidance. They're looking for the training. They're looking for the dollars to flow in to actually teach them, to provide examples, and to provide the supporting programs so that they can actually measure what it exactly they are doing right to provide equity in education, to ensure that they can suss out systemic bias out of their policies and practices, and to intentionally address areas where there are gaps in treatments, in access, and other shortcomings, so as to really be the kind of school district that can provide the kind of quality education that they, as teachers, as administrators, and educators, can actually be proud of offering to their community participants. And I agree that this does need to be both the in and the out, the more holistic approach, because the point is not to come in and constantly point out what somebody's doing wrong. If you, as policy makers and others who are invested in this arena, if we're not also providing, and this is how you make it right, and not only how you make it right, it actually costs less money to do the right thing. The initial cost may be expensive, but the output, not only is it great, when you close the income, the educational gap, everybody succeeds. The nation as a whole succeeds, the community succeeds, and that individual child has a greater chance of succeeding.
Thank you so much, Veronique. We have come already to the close of our time here. I want to again thank all of our wonderful panelists for this input. Maybe this one topic needs to be a multiple series topic. Thank you so much for the rich discussion. And we will follow up and provide links to the resources that were mentioned, including the We Came to Learn report, as well as the Leadership Conference's Principles for a Healthy and Safe School Climate. We will provide links to these resources on the website. And again, we'll also send out a recording of today's webinar. I do want to close with a note about the Civil Rights and Social Justice section, which has for more than 5 decades worked on hundreds of issues, addressing a broad range of civil rights, civil liberties, and international human rights. Today, the section continues to promote policies affecting religious freedom, LGBTQ rights, gender equity, and other significant civil rights issues. So please consider making a donation to the section. You will see the website there on the slide. And your gift will help the section to continue to advance these efforts. And again, please join me in thanking today's panelists for participating in our webinar. And thank you all for joining us for this conversation.
Such an honor.
Thank you.
Thank you.
Thanks, Janelle.
Thank you. Thank you, Janelle.